Hello, this is Matt on the Moon Family Sedan channel, and this was definitely something very unexpected. A third party is seeking to intervene in the SEC v. Ripple lawsuit, and this news just broke today, just literally at the time I'm recording this anyway, just a couple hours or so ago. And who is it that is seeking to intervene? It is none other than Roslyn Layton. If that name sounds familiar, it's because you are familiar with what she's been writing about the SEC v. Ripple case at Forbes. She's a senior contributor, I think that was her title anyway, or is her title, at Forbes. And I've covered every single one of her articles in its entirety about the SEC v. Ripple case and the SEC overreach, all that stuff, since she started writing. I guess it's probably about, I think she was, if memory serves, I think she was pretty well covering the story from the beginning. And she is clearly disgusted by the regulation by enforcement approach that the SEC has been taking. And so we have this filing today, this intervention, and it's 5 pages long. I read the first 2 pages and then I stopped and I was like, I'm just going to cover this thing in its entirety. So we'll get to experience most of it together for the first time, but I did read the first 2 pages already and it is fascinating. So what's it have to do with? Well, you'll see in its entirety here in just a moment, but she is fighting to have the Hinman emails, the Ethereum free pass speech related emails and the drafts of speech made public. And so this went straight to Judge Annalisa Torres in the SEC v. Ripple case. And I'll also share with you brand spanking new comments from attorney Jeremy Hogan and attorney John Deaton. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, and so here is Roslyn Layton, and everything that she writes is absolutely pure fire. It's always a pleasure to cover her stuff. In fact, it got to the point where for some of her articles, they've just been so consistently fantastic, and I acknowledged it at the time, but I was like, I didn't even read this yet. I want to cover this because everything she does is fantastic, and she gets how terrible the SEC is, and she absolutely gets, the degree to which XRP holders have been harmed. And mind you, she doesn't even have a financial interest in this. She has the fire in her belly because she's like, no, this is disgusting government overreach. And so attorney Jeremy Hogan wrote the following. Forbes' own Roslyn Layton has filed a motion opposing the SEC's request to hide the Hinman emails documents from the public. I love how the very first article she cites in her brief is crypto law experts suggest SEC likely to lose. That is awesome. And then he says, well played, with a little smiley face. Attorney John Deaton had this to say about it. I was a big fan of Roslyn Layton before this, and this confirms she is a true soldier versus SEC overreach. It's also an example of what I meant when I said the Hinman emails will not lead to settlement because they eventually will be made public. Can't put that genie back in the bottle. Right, exactly. So with the SEC handing over the Hinman emails, in hindsight, it's a little bit easier to see why that was not something that was ever going to lead to settlement. And so we were, all of us, and I am one of the people that thought that was most probable, ended up not being the case, obviously, to this point. I mean, sure, if we could end up getting some sort of random settlement, okay, fine, but I don't think that's probable at this point. So I was wrong about that, and many others were wrong about that. And that's fine. It's just kind of a guess in the end anyway. But why wouldn't it have been a factor? Well, as Attorney Deaton saliently points out here, it's because that's going to get out anyway. The SEC must know this. So fine, they're putting up a fight. They're delaying all that. Sure, they're going to fight for every inch they can get, the SEC will. But I think they understand it's coming out anyway. So would that be something that would make them settle with Ripple? Wow, when you look at it like that, it's a bit more obvious the answer is no. But I didn't understand when I was supposing that it would, make it more likely that they would settle, the degree to which it's the degree to which it's pretty clear that at some point it's going to come out anyway, because as the SEC continues to sue, there's all sorts of other parties that have an interest in this, some even more so than Ripple. So that's not something that had, that's not a concept that had entered my mind until Attorney Deaton ended up pointing it out. So let's jump into the big bad boy again. 5 pages. And again, I read the first 2, but a lot of this, the first couple pages actually, there's a bunch of footnote stuff, and I'm going to skip over that. So it's actually not that long, frankly. But check it out. So, excuse me. Let me take a sip here. That came out of nowhere. Sorry, folks. All right, so this was filed on behalf of Roslyn Layton by the law firm that she hired here. It's 2 Judge Torres in the SEC v. Ripple case, filed today, and it reads as follows. Dear Judge Torres, Roslyn Layton, Ph.D., by and through the undersigned counsel, seeks leave to intervene in this case to petition the court for access to a set of internal SEC documents relating to a speech that former SEC Director of Corporation Finance William Hinmans gave in June 2018, the Hinmans speech documents. On December 22nd, 2022, the SEC moved to seal some of the Hinmans speech documents that it offered in support of its summary judgment motion, along with any of those documents defendants might reference in their opposition. Dr. Layton opposes that motion. Dr. Layton, a columnist and regulatory policy scholar, is a visiting researcher at Aalborg University, Aalborg. I don't know, probably. It's like Aaron. I don't know what's going on. An executive vice president of Strand Consulting and a senior contributor to Forbes.com. Dr. Layton has no financial stake in Ripple or XRP and no financial interest in this case. But she has written numerous articles about the Hinmans speech documents. In those articles, she has examined the central role those documents play in this enormously significant case, which she has dubbed the cryptocurrency trial of the century. She therefore respectfully requests leave to intervene so she might ask the court to release these documents to the public and to deny the SEC's motion to keep them sealed. You know, let me pause. I don't think I gave my shout out to James K. Filan, did I? That was the first tab I had opened when I started recording this video. I always like to give credit where it's due. Let me just pause for just 1 second here. Back on your screen now. Attorney James K. Filan, member of the XRP community, is the one that shared this and broke this story just within the last couple hours or so. And he tweeted out, breaking, Roslyn Layton has filed a motion to intervene to petition the court for access to the Hinmans speech documents. There you go. All right, I feel better now because anytime I forget to shout somebody out and then I finish recording, I upload, I'm like, damn it, and then it kind of eats at me a little. So I had to pause there for just a second. Anyway, so the legal filing continues, and this section is titled "Argument." That's it. Both the First Amendment, excuse me, both the First Amendment and federal common law endow the press and the public with a potent and fundamental presumptive right to access judicial documents. And then they cite a relevant case that set precedent for that, which I guess in that case it read as follows: a right fundamentally rooted in the need for courts to have a measure of accountability and for the public to have confidence in the administration of justice. All right, and then back to what her attorneys wrote. I'm sorry, folks, I don't know where this is coming from. It goes as follows. That right may not be absolute and varies with the document's purpose in the litigation, but it generally compels the public release of judicial documents absent the most compelling circumstances. That right compels the public release of the Hinmans speech documents given the intense public interest in the case. The Hinmans speech documents, central place within it, and the absence of any legitimate countervailing interest counseling against disclosure. The presumption of favoring public release of the Hinmans speech documents is particularly strong. Well, I'll tell you what, I sure as hell agree with that. Let's see what she says that is the case. The SEC has conceded that the Hinmans speech documents are judicial documents by introducing them into evidence in support of its summary judgment motion, thereby attesting to their importance in determining the parties of substantive rights. And the case for public release of those documents is particularly strong. This case has garnered intense public and media attention, with analysts calling it a critical inflection point for cryptocurrencies, and rightly so. The stakes are extraordinarily high, and not only for Ripple, its executives, and the thousands of XRP holders who have suffered billions in losses from the SEC's misguided effort at supposedly protecting them. This case is also poised to determine the future of cryptocurrencies in this country, serving as a legal referendum on the SEC's entire system of regulation by enforcement for the industry. Woo! I like that. Okay, so that is awesome. So this is a type of message I have rarely seen conveyed, and for obvious reasons, I think, to the judge, because, I mean, you're talking about amicus parties and what, Ripple? So, I mean, and I'm not saying that there's a bunch of weak arguments. I'm not saying there's never been any fire. But what I'm saying is this what the lawyer wrote here on behalf of Roslyn Layton is directly stating, it's saying, hey, you, Judge Torres, are in charge of something of massive, crucial importance for the entire future of this asset class, cryptocurrencies in the United States. Do you it's like the judge didn't understand it before. I think she did though, but she sure would now. It really is that big of a deal, and it happens to be in her hands. So all I'm saying is, I'm just glad that there's an additional person here pushing back and making sure that Judge Torres really truly understands the degree to which whatever she comes up with is going to be highly consequential. And if there isn't some sort of path forward for XRP holders in the United States, her ruling will materially, financially harm an untold number of people, certainly well surpassing the roughly 76,000 XRP holders represented by attorney John Deaton. It'll go far beyond that because not everybody signed up and is being represented by him. So it's a big deal. But anyway, continues. That immense significance has translated into intense public scrutiny of Hinman's speech, which, given the SEC's refusal to provide explicit regulatory guidance on cryptocurrencies, constitutes the only instruction anyone within the SEC has offered crypto stakeholders to avoid the wrong end of an enforcement action. And the supposed guidance Hinman offered in that speech has proven inscrutable, declaring one crypto asset, Ethereum's native cryptocurrency Ether, as completely outside the securities laws, while the SEC seeks billions in penalties from Ripple's virtually identical offering for supposedly violating those laws. The only thing I push back about there, just right off the top of my head, it's probably obvious to you guys too, is similar offerings, identical offerings. Where was the Ripple ICO of XRP? Oh, right, that doesn't exist. So other than that, that's my critique on that. And then says, the inconsistency has given rise to grave concerns about potential conflicts of interest because Hinman had a financial stake in promoting Ethereum to the exclusion of competing coins like XRP. Bam! Now, folks, when you say something like that, I'm told by crybaby Charles Hoskinson, adult man-child, that you're engaging in conspiracy theory speak, a grand conspiracy. So, Roslyn Layton, you might want to retract that because adult man-child, crybaby Charles Hoskinson, is not going to be thrilled with that. Anyway, it continues. Both Judge Knepper and this court have recognized that the internal SEC deliberations memorialized in the Hinman speech documents could therefore prove crucial to the defense, giving the documents a potentially critical role in the exercise of the Article 3 judicial power. Those documents have equally compelling resultant value to those monitoring the federal courts and those evaluating the performance of public agencies and officials in those courts. The Hinman speech documents will show whether Ethereum's proponents within the SEC had undue inference in crafting Hinman's message, or whether agency insiders thought the guidance provided in the speech was unclear or deviated too much from settled expectations. Public access would therefore be crucial in enabling the public to evaluate the strength of Ripple's fair notice defense. Because if insiders within the SEC could not understand the speech's guidance, others outside the agency could not hope to grasp it. And such access is likewise essential in helping the public evaluate whether the SEC's entire regulation by enforcement approach to cryptocurrencies makes sense, whether its pursuit of Ripple is a legitimate use of public tax dollars, and whether the lines the SEC has drawn actually work. All this means there is a particularly strong presumption in favor of disclosing the Hinman speech documents. Now, I find that to be highly compelling, and fine, I'm biased, but could you honestly, in good faith, argue that anything she stated is not a good argument, that it's not compelling? In good faith? Now, of course, the SEC would find a way to try and rip stuff like this to shreds, but They're a bunch of asshat pricks, so I don't care what they think. Anyway, continues. B, there are no countervailing factors weighing against disclosure. There is also no countervailing interest counseling against disclosure. There is no contention that the Hinman speech documents are sought for such illegitimate purposes as to promote public scandal or gain unfair commercial advantage. And the justifications the SEC has offered for maintaining the document secrecy are unavailing. The SEC's contention that this court has declared the documents irrelevant is both incorrect and beside the point. The court determined that those documents could be relevant to the defense when it ordered the SEC to turn them over. The SEC declared the documents are relevant to the summary judgment motions when it offered them in support of its own summary judgment motion. Pause. That's an awesome own. The SEC, yep, these aren't relevant, except for they're relevant because we're going to use them to argue our position. The SEC, it's like the left hand doesn't know what the hell the right hand's doing when it comes to these people. But that's what happens when you're disingenuous pricks. If you're not being honest, you can't even remember that you can't keep your own position straight. You can't keep track of all of your lies and nonsense. So, hey, Hinman documents clearly not relevant. Oh, wait, they're relevant clearly because we're using them to argue points in our motion for summary judgment to win the case. Okay. That's a brilliant point right there. Anyway, it continues. And in any event, in determining whether the Hinman speech documents should be turned over to the public, the document's relevance to the parties is secondary to their relevance to the public. And on that score, their relevance is unquestioned. The SEC fares no better by invoking its supposed interest in maintaining the confidentiality of its officials' non-public deliberations recorded in the Hinman speech documents, because the agency has no such interest. The court has already correctly determined that the documents are not subject to the deliberative process or attorney-client privilege, and the agency has surrendered any right it might have in reasserting those privileges on appeal in this litigation or other litigation. While the agency's mere act of turning over the documents to the defense pursuant to the court's order may not constitute waiver of the privilege, its affirmative use of those documents in the litigation does so. You gotta love that. Maybe you shouldn't have used that as an actual defense in your motion for summary judgment, SEC idiots. Good times here. Anyway, it continues. They're quoting another case here, Ratner versus Netburn. The submission of materials to a court in order to obtain a summary judgment utterly precludes the assertion of any privilege. Okay? And then here's another case, Joy versus North. And privilege may implicitly be waived when a defendant asserts a claim that, in fairness, requires examination of protected communications by the other side. And then here's another case, United States v. Bilzerian. Accordingly, the SEC cannot maintain claims of privilege over the Hinman speech documents while using them in support of its own summary judgment motion, or assert privilege over documents the defendants decide to raise in response to that motion. And outside these privilege claims, the SEC enjoys no residuum of privacy or confidentiality that might prevent disclosure. On the contrary, in the Freedom of Information Act, Congress directed that internal agency communications should generally be subject to a presumption in favor of disclosure. Accordingly, except for a few limited privileged areas, Congress has instructed that agencies' internal deliberations should be made public, deeming the public interest in exposing those interactions to sunlight to be worth any risk to the deliberative process that might result. Damn straight, this is awesome. Indeed, whereas here the very legitimacy of agency action has been brought into question, it is most important to have a measure of accountability and for the public to have confidence in the administration of justice. That is why the Second Circuit recently rejected the Department of Justice's contention that the need to protect the robust, candid functioning of its internal processes and its privacy concerns should prevent disclosure of its internal communications. And the court should reach the same result here. The fact that the Hinman speech documents concern communications among agency officials hardly diminishes the presumption in favor of disclosure. It only suggests the documents are generally available, making the presumption stronger and compelling the conclusion that the documents should be released. For all these reasons, Roslyn Layton, PhD, respectfully requests that the court grant her leave to file a petition for intervention in this action, an opportunity to file a response to the SEC's motion to seal on full briefing, and such other and further relief as justice requires. Ms. Layton also requests to be heard on these matters if the court deems it appropriate. Wow. That is awesome. So I love that. That is incredible. The arguments are obviously very strong. I can only imagine them. See, the SEC always comes up with BS nonsense to push back against any idea, and it's largely just gibberish. That's where you start to see the left hand not knowing what the right hand's doing, crap like that. But it's just so fast. You see, after a couple years or so of Roslyn Layton writing these incredible articles for Forbes on this topic, even though she has no financial interest, now to see that she's jumping in herself when she doesn't have to do this, she's got some fire in her belly. That's pretty damn clear. To go after the SEC like this, calling them out for the BS nonsense, hell yeah, I am down to get down on that party. I'll tell you that for sure. Awesome to see this, guys. Wow. So we'll see what happens. Hopefully, because we were waiting on this ruling. We're like, what's going to happen? Are we going to be able to see the Hinman documents, and to what degree might they be redacted? And so we've been kind of waiting on this anyway. But to see someone just jump in, and it's Roslyn Layton on this topic, absolutely fantastic stuff. So again, I'll keep you posted as I continue to hear stuff. But that's what I got for you now. Totally random thing this evening. I was not expecting something like this. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.